Hello, I'm Dr. Andy Hayward and I'm an Associate Professor in Family Law at Durham Law School. And for this presentation, I'm going to be exploring the familialisation of land law. Now, it might seem a little peculiar that a family lawyer is giving a Land Law Voices presentation, but the purpose is really to show that family law and land law interact. They do so quite often, and sometimes this is a harmonious interaction and sometimes far more chaotic. And this presentation is really to show that some of the concerns and interests that we readily associate with family law often feature, and sometimes quite prominently, in land law litigation. Indeed, the argument that the property in dispute served as a family home and was the base for an interpersonal relationship can often creep into land law litigation. We see this whenever land law courts are dealing with the concept of home, and also quite visibly in mortgage repossession proceedings. Again, we see it with actual occupation, where the fact that the property served as a home may mean that it is a qualifying interest capable of overriding. And then we also see this home dimension feature in the European Convention on Human Rights litigation. Article 8 protects the right to respect for private and family life, but within that is protection of the home in the same way as Article 1 of Protocol 1 protects the peaceful enjoyment of possessions. So we see here that there are various instances where land law is having to grapple with some considerations that normally would fall within the terrain of family law. Now, land law sometimes has to do all the work, and an example of this comes with ownership disputes between cohabitants. Now, cohabitants are not subject to the Matrimonial Causes Act or the Civil Partnership Act. There's no Cohabitation Act that allows a court to distribute property between them. So they are very much in stark contrast, or their position is, to that of spouses as civil partners. As you know, a couple that purchases property together will comply with the standard land law rules of acquisition, purchase, registration, and that will give a definitive statement as to who owns that land. They may then choose to marry or enter a civil partnership, and at that point again, land law determines their property ownership. Marriage and civil partnership does not affect property rights. But if they decide to divorce or dissolve their civil partnership, then the Matrimonial Causes Act and the Civil Partnership Act will allow a court to divide property, including their family home. And this process need not pay necessarily nice regard to legal or equitable entitlement. It's based on fairness and indeed whether or not one person needs property more than another. As I said, cohabitants can't access the Matrimonial Causes Act or the Civil Partnership Act. And this means that their disputes are governed by land and property law. Now, these principles, created from the 1960s onwards, are really deeply unsympathetic to the nature and lived experiences of home ownership by cohabitants. We see that these principles tend to prioritise certain types of conduct. They're often based on intentional bargain. So whilst at law it may mean that property is registered and placed in the name of one person, the other party claiming an interest in the home has to show an intentional bargain that the equitable beneficial ownership is to be shared differently. We know that these arguments as to a bargain often reveal that these bargains just don't exist in interpersonal relationships. Common intention under the constructive trust is widely seen as a bit of a myth. Equally, the conduct that we want under these principles tends to be quite mercenary. It often responds to what's been called the solid tug of money. Simply looking after the home, doing homemaker activities, childcare, is not capable of triggering a trust. You have to directly contribute to the acquisition. So as such, they have been regarded as a set of relationship-blind principles. So this is where familialisation of land law comes in. These principles have been criticised for quite some time, but there has been some evidence to show that they have been subject to familialisation. Now, before I go into the examples of that, I want to talk a little bit about what is familialisation. Other than being a really difficult word to pronounce, familialisation is coined by John Dewar as a process by which both judges and legislature have modified general principles of land law or trusts to accommodate the specific needs of family members. So it's an intuitive process largely driven by the judiciary to take a property or land law rule and to soften and modify that rule so that it is more cognizant of the context in which it operates. Now, for me, I would welcome familialisation as something that is a modernising force. It allows the law to evolve, and that's really key in the modern context of cohabitation. We know that cohabitation is the fastest growing family form in the UK, and at present there is around 3.5 million cohabiting couples in the UK. It also allows protection for vulnerable parties. So parties that can't fit within the land law framework of showing an express bargain or making a requisite contribution. Familialisation can be there to try and soften those exclusionary rules and allow a greater pool of individuals to benefit from those principles. And it also is something that recognises that the home in dispute, the land in dispute, is the foundation and it's the environment of that interpersonal relationship. It acknowledges the lived experiences of the parties. But familialisation is also a deeply contested and controversial topic. For some land lawyers and even family lawyers, they would say that it often sanctions judicial activism. And there have been some cases where that is clearly present. It can be something that is disruptive. It creates uncertainty. It injects too much discretion. And these can be bad things, particularly for third parties that need to know where they stand. And indeed, John Dewar himself accepted that familialisation as a process was one that was imperfect and actually affected the conceptual orderliness of land law itself. So let's look more closely at some examples of familialisation in this context. Now, there's some earlier examples within the development of the trust principles in this area that suggest familialisation. One would be the existence of express common intention constructive trusts. The ability for a party to be able to acquire an interest in property owned at law by another party through an express common intention constructive trust, through an agreement, has been identified by John Dewar as an example of familialisation. Because prior to that point in time, the courts were really looking for particular types of contribution, and this was largely under the resulting trust. Resulting trusts would be focusing on monetary contributions. So by broadening out the basis or the routes in which you could claim an interest, by allowing instead an agreement to share property and equity, that could be viewed as familialisation by allowing greater access to a beneficial interest in the home. Equally, non-financial contributions as a basis of detrimental reliance, that has been seen as familialisation. So as you know, an express common intention to share beneficially, an agreement, an arrangement, an understanding to share beneficially under the principles of Lloyd Bank and Rossett is not enough. There must be detrimental reliance on that agreement. Now, the courts from Grant and Edwards onwards have shown that that detrimental reliance doesn't have to be financial in essence, and it could be a non-financial contribution such as childcare or domestic contributions. So we do have some early examples of familialisation at the acquisition stage, but generally speaking, these principles are noted to be quite restrictive, quite conservative and exclusionary. Quantification is an area, the second area after you acquire an interest in a home, where there is much greater evidence of familialisation. And the quantification principles that really exemplify this trend come from the House of Lords decision in Stack and Dowden and the Supreme Court decision in Jones and Kernot. And what we see in this particular later stage of a claim is much greater evidence of this enhanced familialisation. So what does this familialisation involve? Well, firstly, we have a focus on context. Stack and Dowden, in particular, the statement that in law, context is everything, created a dichotomy between the domestic and the commercial sphere, and said that within the domestic sphere, different rules should apply, and these should be appreciative of that context. So that could arguably be an example of familialisation. Another example is this strong presumption of beneficial joint ownership, or beneficial joint tenancy. So this principle comes out of the idea that where you place property in joint names at law, equity follows the law, and therefore prima facie you'll be sharing that property equally in equity. Now, this idea of equity following the law isn't new. This presumption of beneficial joint tenancy, again, isn't new. But what was new is that in the past it was very easy for you to dislodge that presumption. And you could do that by showing unequal contribution to the acquisition of the property. What Stack and Dowden does is say that where property is placed in joint names, it'll be a heavy or strong burden for one party to dislodge that and to share unequally in equity. And this, if we work that through, can again be seen as an example of familialisation. Because what they're saying is where you have a domestic endeavour of cohabitants purchasing property together as a home, then prima facie, that should be something that should be shared. Now, where you want to show that your property ownership and equity should differ from that in law, then you can displace that presumption of beneficial joint tenancy. And one method for doing this is to show a common intention to share unequally via the paragraph 69 factors. These factors are really quite interesting. The reason being, as some have argued, they resemble in some ways the section 25 factors that are used in the Matrimonial Causes Act to divide assets between spouses. We can see within the factors, regard can be had for the purpose for purchasing the home, the nature of the parties' relationship, their own personalities and characteristics, whether it served as a home for children. And these factors are also not restricted. Other factors and considerations can be taken into account when divining the parties' true common intentions. And then lastly, the sanctioning of fairness. So if you cannot determine precise shares, whether express or inferred shares, you can instead use fairness and impute to the parties a fair share. That, again, often resonates with family law considerations, fairness featuring so prominently within the division of assets between spouses and civil partners. So here we see a system where the acquisition stage governed by Rossett, that the rules largely are not that familialised, but at the quantification stage, much greater scope for familialisation exists. But the difficulty there is that it is harder to get to that quantification stage. You have to jump the hurdle, the quite restrictive hurdle laid down in Rossett. We also know that familialisation has stalled a little too, because in Stack and Dowden, there were observations made by Lady Hale and Lord Walker that the time has come for us to perhaps relax the restrictive rules on acquisition laid down in Rossett, and that the hurdle, the bar, had been set too high. And so there was a call to arms in Stack and Dowden for lower courts to try and relax these principles and make them more familialised and cognizant of the family dimension. But through the work of Brian Sloan, and if we track the case law development, we see that this familialisation hasn't really happened. And whilst there were a flurry of cases around the time of Stack and Kernot, these have slowed down, and there hasn't really been an opportunity, indeed one that has even gone to the Supreme Court, where the Rossett principles can in fact be revisited. Another area of familialisation exists within proprietary estoppel. Now, after Fauna and Major, an important House of Lords decision in this area, there is potentially greater scope for estoppel to be used by cohabitants and to be used in the domestic context. Now, as is known, a proprietary estoppel claim requires a representation or assurance as to a future interest in land that is relied on by the claimant to their detriment in a context that exhibits unconscionability. Unconscionability is not a separate element but runs through all of those constituent elements of the claim. Prior to Fauna and Major, it was quite difficult to actually establish a claim on that basis. But after Fauna and Major, we see some familialised elements creeping in. One idea is this idea that the representation that needs to be used as the basis of a estoppel claim must be looked at contextually, and that in a domestic context where couples don't speak with great precision as to property entitlement, the courts can be accepting and can acknowledge that haziness and therefore not unnecessarily defeat claims. We also have an expansive view on detriment. Detriment in the estoppel context extends not only to financial detriment, but also, again, non-financial. And there's also greater remedial flexibility with estoppel. Estoppel can be used much more creatively. And if you are able to obtain a remedy using estoppel, you're not limited to a trust interest like you are under an implied trust. You could have a monetary payment, for example. So this scope for familialisation of estoppel has certainly got some evidence in Southwell and Blackburn and Lydon and Burton. Southwell and Blackburn saw the female claimant in that case obtain £28,000 monetary payment after successfully proving an estoppel claim. She did this because she was encouraged by her partner to give up her secure accommodation and then move in and live with him and relocate. And the constituent elements were then found to be established in that case. So whilst that's a welcome case and has in fact been lauded by Resolution, an organisation of family law practitioners, as a landmark decision, we have to think a little bit more cautiously about it. Can those principles be developed further? Can they be familialised further? Well, there are certainly some risks. We know that in the cohabitation context, just like it is hard to prove an express agreement to share beneficial ownership, equally it's hard to prove an agreement, or rather a representation that could form the basis of an estoppel. We also see that contextual analysis, where we look at all the features of the case, can be problematic in estoppel because it means that a lot of what has been done and said becomes essentially background noise. It just becomes context, and that might defeat a claimant who is trying to say that their conduct is directly referable and relates to the representation that was made by the defendant. And so there are some concerns and risks about using estoppel in this context. Another feature as well is that an estoppel remedy can be denied if it's believed that the detriment that the claimant has suffered has in fact been rectified or remedied by the benefits that they equally enjoyed. So you could offset a detriment by the other party showing that you did in fact receive benefits. But ultimately it goes back to the idea of, in this context, people having to be a little mercenary. And that sometimes is incompatible with the nature of interpersonal relationships, where people often are motivated not by financial considerations, but by love and natural affection. In estoppel claims, it is for the party to show that they performed a particular act, a detrimental act to them, not because they loved the other party and they wanted to actually pursue that interpersonal relationship further, but because they were motivated by the representation that was made by the defendant, and that sometimes can be very difficult to do. So where do we go from here? Well, familialisation, as I said, is a contested and controversial process in land law, and we know that if we push it too far, it really does challenge the fabric of land law. And interestingly, after Stack and Dowden and Kernot were handed down by the House of Lords and Supreme Court, the landscape was criticised by Martin Dixon. He went so far as saying, call it family law, call it an exercise of the court's inherent equitable jurisdiction, but maybe do not call it property law. So where familialisation is rampant and it goes too far, it can sometimes make an area seem no longer land and property law. But for me, where you have an area of pressing social concern, and that is the fact that cohabitants are vulnerable and lack legal protections, I think the only option, if we're going to reconcile land law with the lived experiences of these people, is principled familialisation.